This is CDBG Bootcamp Module 5, Keys to Conveying CDBG Compliance in Your Application. The topics we will discuss in this presentation are as follows.
The first topic today is property acquisition requirements. The applicable law is the Uniform Real Property Acquisition and Relocation Assistance Policy Act of 1970. This is also referred to as URA requirements. The regulation for the URA requirements can be found at 49 Code of Federal Regulations, CFR, Part 24. URA applicability, when regarding your application, pertains to the purchase of land for buildings, right-of-way for streets, easements for water, sewer, drainage, etc., and all other acquisitions for CDBG projects, regardless of the fund source, i.e., local funds. If your project involves acquisition and it involves CDBG funds, even if there are other funds involved, URA requirements apply. Whenever your CDBG project requires acquisition, there are basic requirements that you should be aware of. First, preliminary notice of intent to acquire and the URA protections brochure must be provided to the owner. The amount paid to acquire the property must be based on an appraised value. Donations of land are acceptable, but only with a waiver. The owner of the property being acquired must be offered fair market value for the property, and there must be a written purchase offer. If you know your CDBG project will require property acquisition, include in your application, if applicable, the ownership status of the property needed for the project, the number of parcels and the estimated cost for such, the indicator of your readiness to proceed. In other words, information such as the owner has been contacted, an offer has been made, offer has been accepted, attorneys have cleared the matter, etc. Completion of these items and them being included in your CDBG application may result in a bonus point for your application. Our next topic pertains to conflicts of interest. Your CDBG application should address conflicts of interest that are known or there may be of a potential. These would include conflicts involving financial and personal interest, persons who may be affected or is referred to as covered officials would be elected officials and their family members, and key staff of your local government. Please note that DCA can grant an exception but not a waiver. If you find that your application has a conflict of interest, you may request from DCA a conflict of interest exception. There are requirements that must be met in order for DCA to provide the exception. Firstly, there must be public disclosure of the conflict made by your local government. There needs to be a public meeting to discuss such conflict. This public meeting must have a posted agenda minutes must be maintained. Also, those persons or person affected by the conflict of interest must abstain from any vote or discussion regarding the CDBG project. The city or county attorney must issue an opinion that the said conflict of interest does not violate state or local laws. Please include in your CDBG application a target area map showing the affected party's interest. For example, if a city official has a close relative that owns a home or lives in the affected target area, please provide a parcel map showing the location of this property. And again, include this in your application. In order to become more familiar with the conflict of interest requirements, I would suggest that you review Appendix F and DCA Form 10 in the applicant's manual. Please note that the conflict of interest exception granted by DCA is an exception to the regulation and not a waiver of the regulation. Also, please note that should a conflict be identified in the future that was not noted in the application, that this conflict of interest must have its own separate exception granted. Our next compliance topic is lead-based paint, or LBT. If your application requires the rehabilitation or reconstruction or renovation of any structure built before 1978, a lead-based paint evaluation is required. The evaluation must be performed by an inspector or risk assessor who is licensed and certified by the state of Georgia. Due to the somewhat scarcity of inspectors and risk assessors for LBT evaluations, you must be prepared to seek services outside of your local area. And also, please consider travel and other expenses when preparing your estimate. Please note that lead hazard control can be costly. A suggestion is to budget 25% of an estimated rehabilitation cost for lead hazard control. Also, lead hazard control works rules frequently change. Please stay current of the latest changes. Please ensure that you include in your application and demonstrate an understanding of LBT regulation requirements. Our next compliance requirement for your CDBG application is environmental review requirements. It is an obligation of CDBG recipients to comply with NEPA related laws and authorities. The related laws and authorities list can be found at 24 CFR 58.5. When preparing your CDBG application, you must assess and evaluate any environmental effects the project may have. You must minimize and mitigate any adverse effects caused by your project. There must be public notification, and do not obligate any funds until the environmental review release of funds has been issued by DCA. Should the environmental review requirements be completed and included in your application, you may be eligible to receive an application bonus point. Since environmental review requirements can be quite detailed, additional training may be required. Additional training for environmental review requirements may be found at the DCA CDBG Recipients Workshop. Also, HUD provides training via webinars, as noted by the website on the slide.
As you plan your project, you must consider neighborhood impacts and avoid or mitigate impacts that may harm residents. You must also consider historic preservation for historic structures, including demolition, the reuse and rehabilitation of historic resources, and new building in a historic neighborhood.
Additional information to consider regarding environmental review requirements are floodplains and wetlands. Be sure to include maps that show your target area and any floodplains and wetlands that may be affected. Need to consider cultural and historic resources, including Native American consultations. Need to consider archaeological and building and structural information. There are various types of environmental reviews, each with its own set of requirements. One particularly is known as a Phase 1 review. Generally, a Phase 1 review will be needed for a CDBG project involving buildings or the acquisition of property. Additionally, you will need to conduct what is called a tribal consultation to determine the affected tribes for your project. There is a checklist that can be located at a website called TDAT. This is a Native American consultation. A tribal consultation is similar to a Section 106 review, and there is a checklist that includes this on DCA 9B. The last compliance item we will discuss today is generically known as the Davis-Bacon Act requirements. These federal labor standards requirements require prevailing wages for construction projects. Also, federal labor standards requirements involve what is called the Anti-Kickback Act or the Copeland Act, and complies with Contract Work Hours and Safety Act. This topic will be discussed in further detail in the DCA CDBG Recipients Workshop Training.
Should you have any questions regarding any of the topics discussed in this module, please submit those questions via email to cdbg.biz@dca.ga.gov, and please use the subject line Bootcamp Questions. We will provide answers in reply and at the workshop.